A living will and a last will and testament sound similar, but they do completely different jobs. Today, I walk you through both and explain why one recent court decision in Michigan makes this conversation more important than ever. I'm Jill Mastriani, an estate planning attorney and host of the Death Readiness podcast. If you don't know what you're asking for, you're not going to get what you want. In 2003, I went to St. Petersburg, Russia for a study abroad program. I was a Russian major, so you'd think I'd be prepared, in theory. In reality, this was basically my first time abroad, unless you count a quick 8th grade trip to Canada after a track meet in Buffalo, where my dad took me to see Niagara Falls from the Canadian side. So, not exactly extensive international experience. About a week before I left, I was sitting at my Aunt Eileen's dining room table with my family, and I joked that my Russian skills were about on par with my 2-year-old cousin's developing language skills. She was sitting next to me in her high chair. I could say things like, I want potato. Я хочу картошку. And not a whole lot beyond that. Fast forward to Russia. I figured out the subway, got to class, and started to feel a little confident. I decided it was time to go grocery shopping on my own. I grabbed some bread and thought, I'll get some cheese. It seemed simple enough, except it wasn't. I didn't really know how to ask for how much cheese. So I stood there, nodded confidently, and watched the person behind the counter cut what can only be described as an absolutely enormous block of cheese. A block so big I wasn't sure it would fit in my host mother's refrigerator. And of course, I pretended that was exactly what I meant to order. Turns out I didn't know how to ask for what I actually wanted. Estate planning might be in English, but it can feel like a different language. And if you don't know what you're asking for, you can end up with something very different than what you intended. Also, here's a quick full circle. That little cousin in the high chair is now the client care coordinator for my law practice and built and maintains the Death Readiness website. And now we get to work together every day, which feels like a pretty great full circle. Before we get into today's episode, I want to give you a preview of what's coming next and a chance to get your questions answered. I know it's been a lot of solo episodes this past year, but guests are coming back. And one of our next guests is Blair Martin, a financial advisor. I spend a lot of time making estate planning make sense. Blair does the same thing with money. She's also my financial advisor and a good friend. A couple of years ago, after I lost my job, she called to check in and asked if I wanted to walk through my finances with her. She wasn't trying to sign me as a client. She was just using her skills to help a friend who needed it. I was in a vulnerable spot, and she was exactly the person I needed. So now I want to bring that same kind of support to you. If you've been wondering things like, can I actually afford to retire? Do I have enough to help my adult kids now without putting myself at risk? And am I doing the right things with my money or just hoping I am? Send me your questions. Blair's going to be here to answer them. You can email me at jill@deathreadiness.com. That's jill@deathreadiness.com. Okay, let's get into today's episode. A few nights ago at dinner, while I was deciding which question to answer for today's Tuesday triage, I asked my husband and daughter if they knew what a living will was. My husband said he didn't. My daughter said, "Isn't it just a will you make when you're alive?" She's not correct, but it's not a bad guess, and it's exactly why this question comes up so often. This question is from Ike in Michigan. He came to a workshop I gave a couple of weeks ago called How to Write Your Own Will and Why You Shouldn't. I'll link to the podcast episode on that topic in the show notes if you want to go deeper. During the workshop, I walked participants through how to write a holographic will, which is a will entirely in your own handwriting. And under Michigan law, that can be valid if it's signed and dated. At the end, Ike asked a really good question. How do I know what goes in my living will versus my regular will? So that's what we're tackling today. What is a living will, and how is it different from a last will and testament? Because Ike is in Michigan, I'm going to answer this based on Michigan law, but the big picture is the same across the country. A living will and a last will and testament are two completely different documents that do two completely different jobs, yet they get mixed up all the time. So let's start with the living will. A living will has nothing to do with your money or your stuff. It's about medical decisions, specifically what you want to happen if you're alive but unable to speak for yourself. Living wills are really important if you have a serious illness, are in a terrible accident, or are facing other end of life situations. It answers questions like, do you want life support? Do you want certain treatments continued or stopped? In Michigan, the person who makes these decisions for you is called your patient advocate. And the language around this can be pretty direct. You'll often see something like, I authorize my patient advocate to decide to withhold or withdraw medical and mental health treatment, including the provision of artificial nutrition and hydration, which could or would allow me to die. I am fully aware that such a decision could or would lead to my death. Michigan doesn't technically recognize a standalone living will as its own legal document. Instead, those end of life decisions get built into something called an advance directive. And in Michigan, that advance directive has two key pieces. The first is what most people think of as the living will part. This is where you spell out your wishes, what treatments you would want, what you wouldn't want, and how you feel about things like life support if you can't speak for yourself. The second is the patient advocate designation, where you name someone to step in and make medical decisions for you if you're unable to make those decisions yourself. A living will gives your people a roadmap. It helps them make decisions with confidence instead of guessing in a really difficult moment. And this is actually an area where the law in Michigan just changed, literally within the last few days. On April 16th, 2026, a Michigan trial court issued a decision that directly impacts how advance directives work. Until now, there was one major limitation. If a patient was pregnant, a patient advocate could not choose to withhold or withdraw life sustaining treatment if doing so could result in the patient's death, even if that's what the patient had clearly expressed they wanted. So in that situation, the patient's prior decisions did not control. That restriction was built into Michigan law and even shows up in the standard patient advocate forms. In October 2025, a group of patients, doctors, and advocates challenged that rule in court. They argued that it violated Michigan's constitutional protections around reproductive freedom. In 2022, Michigan voters passed a constitutional amendment, often referred to as the Reproductive Freedom Amendment, which gives individuals a fundamental right to make and carry out decisions about pregnancy and related medical care. The plaintiffs argued that deciding whether to continue or stop life sustaining treatment, even during pregnancy, is part of that protected right. Now, here's what makes this case a little unusual. The state defendants, including Governor Gretchen Whitmer, actually agreed with the plaintiffs that the law was unconstitutional. So you might be thinking, wait, if everyone agrees, is there even a case? And the answer is yes. In this case, the court recognized that even though the current officials agreed, that could change. New officials could take office, and as long as the law stayed on the books, hospitals were still required to follow it. So without a court decision, the risk and the confusion was still very real. And the court agreed. Judge Seema Patel struck down that pregnancy restriction, which means doctors and patient advocates are no longer automatically blocked from honoring a pregnant patient's wishes about life-sustaining treatment. This case was about one question. Who gets to decide a pregnant patient's fate? The patient and the person they chose to speak for them, or the state? At least for now, the court came down on the side of the patient. Now, let's move from living wills and advance directives to a last will and testament. A last will and testament has nothing to do with medical decisions. It only comes into play after you die, and it answers a completely different set of questions. Who gets your probate assets? Who's in charge of wrapping things up? And who's taking care of your minor children? It's your instruction manual for everything you leave behind that doesn't pass automatically by, for example, beneficiary designation. So if we zoom out, here's the simplest way to think about it. A living will is about decisions while you're still here but can't speak. A last will and testament is about decisions after you're gone. A living will is medical. A last will and testament is financial and administrative. They don't overlap, and you really do want both. But this isn't just about documents. A living will gives the people in a hospital room direction. A last will and testament gives your family structure when everything feels uncertain. And both give them something even more important: the confidence that they're getting it right. One more thing before you go. Blair Martin is coming on the podcast soon, and I want to make sure we're answering the questions that are actually on your mind. If money feels a little unclear, a little overwhelming, or like something you've been meaning to figure out, this is your chance. Send me your questions at jill@deathreadiness.com, and we'll tackle them together. Thanks for listening today.